Sun life disability lawsuits are something that can be very challenging. Rachel, that when these claims are denied and they're governed by ERISA, which is probably 99% of what Sun Life sells to people, that the claimants don't necessarily have a level playing field. And they definitely can win these cases, and we win them all the time. And we're going to talk later about what a win means. But I also want people to understand why, when they look up ERISA and why they hear about this, a lot of people who know what, if they know what they're doing in this industry, can say, this is going to be a challenge. It's almost never a slam dunk case for a claimant. But out of the box, why is this not the traditional type of trial/lawsuit that people see on TV?
Well, when you watch TV and you see a trial, and you see, oh, there's somebody, a lawyer's up and he's picking a jury and talking to a jury, and he's cross-examining witnesses, and the judge and the jury get to meet the plaintiff, and this is not that type of case. So unfortunately, with ERISA claims, there's no juries, there's no discovery, there's no witnesses. It's just a judge, in a bench trial who never meets the client, who just does a review of the administrative record, which is the claim file, which is everything that goes into the claim. And the judge renders a decision whether he or she believes that the insurance carrier was arbitrary and capricious in denying the claim. So there's when the client says, oh, my case is easy, I'm so sick, the judge will see me, he'll see how sick I am. But unfortunately, that's not how it works. They don't get to meet the claimant. They don't get to even meet the lawyers. The lawyers don't even get to do oral argument 9 times out of 10. It's just the judge reading our motions, reading everything that went into the claim and the appeal beforehand.
So with that, what a lot of claimants don't know to ask law firms when they're looking out to say, hey, who do I want to hire, is what is the lawyer's understanding of all the case law out there? There's thousands of cases. How many lawsuits have you actually had against Sun Life? How many cases have you had that have actually gone to a judgment or an opinion? Like, does Sun Life even know who you are? Are they going to take you seriously? Are they going to make you battle them because you have no street credibility with them? And so that's something obviously that we have from doing this for more than 25 years of litigating every single day all over the country. But it also gives claimants the opportunity to get tremendous, not only firepower behind them, but value in where the case is going to go. Because in these ERISA Sun Life disability lawsuits, 99% of them resolve in a settlement. Talk about what a settlement is versus the outcome that someone can have if it's not a settlement that's reached.
Sure. And a lot of claimants don't understand this, because why would they? They don't have the experience. So a lot of clients will call me and they'll say, okay, I want to take my case to court, and I've done the math and my claim is worth $1 million if they paid me to age 65, even though they may be only 35 years old today. And I would say to them, okay, but if we go to court, that's not going to be an award. It's not going to look like that, because according to ERISA, all a judge is permitted to do, if we are to win the claim, is to award back benefits that the claimant is already owed to date. So, for example, if the claimant was denied 6 months before, it took us 6 months to do, to get everything ready. They're in court now, we're in trial, so there's a year of benefits owed, and that could look like maybe $25,000, for example. So if we were to win in court, a judge can award that back pay of $25,000. Then they're permitted to remand the claim back to Sun Life to do another review, and to determine at that point if they believe the claimant is disabled going forward, which, who knows what could happen. That could be a yes, that could be a no. You could end up having to do an appeal again, and this could go on for a very long time. The claimants usually aren't very happy with that, but that's the way it goes. The judges are also permitted, if we're the prevailing party, to award attorney's fees. So that is something that the claimants can get if they win. But they're not going to get the $1 million judgment from the judge.
Right.
And I always explain this to them at the beginning so that they understand and they have reasonable expectations, that if we do try your case and we win, you could be getting less money than you would get possibly in a settlement from Sun Life, because they will consider in a settlement the back benefits, and part of the future benefits will usually be included. So a lot of times it's worth the risk of going to court and proving that Sun Life is arbitrary and capricious is very high. These cases are often ruled by judges in favor of the insurance company, not because the person is not sick or they don't seem to be disabled, but it's the way the law is written. It's a very hard standard to prove that they did not have at least one reasonable basis to deny the claim. So oftentimes, like you said, over 90% of our cases, 98, 99%, are actually settled out of court because it ends up being a better situation for the claimant to settle than to risk going to court, possibly losing, or getting a judgment that's nowhere near what they're willing to pay them for a settlement.
And I like clients to know right now as they're sitting there saying, hey, do I want to call this law firm? Do I want to, what am I going to do? And what I suggest is they should call and send us a denial letter, because what we want to do is immediately look at that. We may need the claim file, which is the entire record of what happened after the appeal was submitted, but we're going to be able to get a reasonable value on what the case is worth and what we think are the chances of winning this particular case. And the one thing that we do is we're very practical, and we could say, look, let's go on a worst case scenario. I think this case has a 10% chance of winning. Some law firms may look at that and say, we shouldn't pursue this case at all. But if you have a 10% chance, we want to fight for the claimant. How do we get to that 10% chance? The way that comes, in my opinion, is from having a mastery of the case law. And when I say a mastery of the case law, there are thousands of cases in the world of ERISA, and I call it the wild, wild west. Cases come from decisions that other courts have made all over the country. We have 15 lawyers who do nothing but this. We see cases every day. We've been involved in cases all over the country. What you need to do to win this case once it gets into this trial on the papers is you have to really understand all of the case law. You've got to find the cases that are going to support your position. And while Sun Life may come to the table and go, Rachel, I got these 5 cases that are against your client, and we show up and go, well, what about this one? Now all of a sudden they're going, yeah, we have 5 and they might have 1, but what happens if this is a new area of the law? What if this is something that this judge or the clerk that's helping the judge goes, I think the facts of this case warrant what that other judge did. Now Sun Life doesn't feel so strongly to say, we're going to win this no matter what, we're not paying you a dime. That works to the benefit of the client. You still don't have a great chance of winning, but instead of saying, I'm going to give up, I'm not going to do anything, let's fight and be realistic, but let's fight it in a practical manner. Let's not just fight because we're pissed off at Sun Life and we want to go the distance, because I also don't want to expose the client to attorney's fees. Potentially, if the client loses, they could have to pay their attorney's fees. But let's have an upfront conversation and say, look, I think I can get you money. Otherwise, I'm not going to waste your time, because remember, we don't handle these cases unless we don't take a case and get paid unless we recover money.
Right.
So, but if we're going to tell you up front, hey, the most we're going to get on this case is X, and the client goes, you know what, I'm okay with that, then we'll move forward. But if you're someone who just wants to fight because you want to fight a battle that's a losing battle, well, we're not going to go on a suicide mission. So, and we're not going to blow smoke to you to make you think, let's just sign up the case because we'll tell you this is what it is at the end of the day and take it or leave it. It's not that way, because we don't run a volume practice either. We're very specific on our cases. We're going to work very hard, and we're going to have level expectations with the client and let them know. The other thing we're going to do, Rachel, that you know, is we're going to act quickly, because we know they're sitting there with no money coming in. Time is money. Even if we were to say, you want to go all the way, that's fine. It's a 1.5 years minimum, guaranteed by the time the judge makes a decision. And then likely they're going to appeal, maybe another 12 to 18 months minimum. So you're 3 years down the road. You know, it's not a perfect system, and there's nothing we can do necessarily to make it move faster. But with ERISA, you know, you do get the benefit of the doubt that you're in federal court. The judge is going to put a tight timeline. And I do have found lately that these judges are pushing you to early settlement conferences. They're pushing to fast summary judgment deadlines. And then the courts are supposed to render a decision within 90 days. They often don't, but the judges want to move these things. So that is one of the benefits of having this case be done through ERISA. And we've had many successful settlements with Sun Life, which can be to the benefit of the client. So there's hope here, but at the end of the day, the client is the captain of the ship. You know, we know how to drive it, but they're the captain. You want to go? We'll go. You don't want to go? We won't go. More often than not, we want to go the distance, and the client wants to take the money. because they're unfortunately stuck in a really hard position. So thank you for talking about this. And if you're someone out there who has a Sun Life disability denial, feel free to contact Rachel, myself, any of our lawyers. Send us a copy of your denial letter. We'll get on the phone with you right away, and we'll have a free phone consultation, and we'll let you know if we think we can help you.